Welcome to Make It Last, helping you keep your legal ducks in a row and your nest egg secure, with your host, Victor Medina, an estate planning and elder law attorney and certified financial planner.
Hey everybody, welcome back to Make It Last. I'm your host, Victor Medina, and I'm so happy that you're joining us today on our program. We have some great stuff to talk to you about. You know, everybody has IRAs and 401ks these days instead of pensions. It used to be worked for a company for a long time, and then they would give you a pension when you retire. Well, those days are over, and more folks are relying on the savings that they have in an IRA or 401k. Now, some people have done a very good job of saving money in there, such that there's probably going to be stuff left over when they die. Well, what happens to that account and how you can transfer it to minimize the tax and trouble, that's going to be the focus of today's show. And we're going to cover that in segments 2 and 3. In segment number 1, though, I did want to talk to you a little bit about something that I'm doing in my professional career in terms of getting another designation and why I've been surprised by that process. So, you know, it's interesting. You know, if you look at the business card of any financial advisor, they love to tack on initials at the end of whoever they are, right? So there'll be CAFE, F241, whatever it is. They've got a long list of initials. Now, in my experience, clients are less impressed with that than the advisor is on it. You know, the advisor is looking for some way to kind of legitimize what they're doing, and they go out and they get these credentials, and there are a wide spectrum of how valuable that credential can be. So I'll give you a comparison. One of the, well, I have, let's say I have 2 credentials right now that I could put on my card, right? I could put JD and I could put CFP. Now, JD is for my law degree, right? So if I wanted to sound really impressive about what it is that I was doing, I would say, okay, Victor J. Medina, financial advisor, right? Because that's in the financial company, but JD, to let you know that I went to law school. Now, I don't know what that says other than I went to law school and I graduated, right? It doesn't say that I'm a practicing lawyer, and many financial advisors who have JDs are not. I happen to be a practicing lawyer, but you'd only know that if you knew about my law office or if you got to know me, you know, through the law side for the estate planning, and then you came talk to us about financial. But so they got a law degree, right? It says I got a law degree, and it doesn't say anything about my ability to practice in the area. There's nothing about a law degree that says that you're going to be a good financial advisor. Now, I happen to have spent 10, or 15 years or so in the practice of law, and most of it in the area of estate planning and elder law planning. So I've gotten the tested in the trenches education on it. But the idea generally here is that there's a credential there. The CFP, that's a pretty good credential because that means that you went through a sort of rigorous set of examination experience and education standards that they're putting out there, where you've got to pass an exam in 6 areas of core competency. You've got to have a bent towards financial planning. You have to sign on to an ethics agreement about the fact that you'd be focusing on planning and acting as a fiduciary. So that's all pretty good. And I got that credential last year. But then there's a credential all the way on the other side. And this credential essentially is like a weekend course, or even less than that, where what you do is you have to sit in a class for about 4 hours and take an exam, and it's all self-administered, and it's an open book exam. But at the end of it, you can become, I don't want to denigrate all of them, but any of them, but let's say that you're like a certified senior living advisor or something or other, right? You can get this credential. Now, the general public tends not to understand the difference between those credentials and what it takes to get them. We who have gone through that know that. So I went to law school for 3 years, and at the end of it, first of all, I had to graduate. And then after that, I had to pass a bar exam. And I happen to have passed 3 bar exams with the ability to practice in 4 jurisdictions. Okay. So there's something about that law credential that smacks of some gravitas, right? It's chunky because you went to school for 3 years, and then if you're a practicing lawyer, you've passed the bar exam, at least one, and those things aren't a cakewalk. Same thing for the CFP. That's a pretty chunky credential. But on the other side, the weekend course, that's not as rigorous on there. Now, there are websites out there that will actually help you figure out which is which. So you can go to, I believe it is a designation check. And if you go to designationcheck.com, what you're going to be able to do is find a designation and learn about, different kinds of credentials, what they mean. It will tell you how long it takes to get it, what kind of examination is there, whether or not there are any continuing education requirements on it. And there are about, I'm looking at the site now. There may be 20 different ones on there. And that's not all of them, by the way. That's not all of the credentials that are out. They just happen to be the ones that are on designation check. And it's a good way of kind of, making sure that there are, that there's something behind it. That there's something behind it. Anyway, I've wasted now out of this 8-minute segment about 6 minutes or so telling you about the different designations, but not telling you the story that I wanted to tell you. And the story that I wanted to tell you is that I'm in the midst of getting another designation, and I was surprised. We're focusing, and we do focus in our financial area on people who are nearing or in retirement, and specifically about making sure that we can help them manage the assets that they have set aside, their income, their Social Security, fixed income, whatever it is, and making sure that they don't outlast their money. That's our goal. And so I thought, it'd be helpful to get another designation in the area because I'm more interested in the education than the credential. I really haven't decided whether or not I would use this credential or not. And I'm in the process of getting it, and I signed up for it. It cost about $2,000 to go through the program. It's 3 college-level classes, and you do it on a self-study, and then you schedule your exam when you're ready to go. So in this case, I signed up for the program on a Thursday. And as I was taking the pre-exam, I realized I knew a lot of this stuff. So I ended up scheduling the final for the next Monday. And I spent the weekend reviewing the materials, but, I didn't pull any all-nighters. Geez, I'm too old for that. There's no chance in the world I'm going to be spending all night studying for this. But I thought, there's a pretty good chance for me to pass that exam if I just kind of review the materials. And I sat for the exam on Monday, and I passed it. And I was surprised about the amount of knowledge that I had already that they were trying to teach me. And I think that there's something to be said for having the experience in an area and not necessarily relying on the credential to get you there. Now, there's 2 other modules in here. I'm in the midst of the next module. I think I'll probably take a week of study before I'll take that exam. And my goal is to wrap this up in about 30 days, even though it's a program that's meant to go about... it's about to go about a year or so. Some people do it in about 6 months. But I'm going to try to do it in about 30 days. And I think that I've got a good shot at doing that. And for the most part, because I know this stuff. I will like the credential just to know that I've completed, that base minimum stuff that they're looking for. But it'll be an interesting journey for me to have this conversation with clients and really ask them, do you care that I have this credential? Is it important to you? Because we don't rely on that stuff too much. We've got a lot of steak that we sell people, and we're not really relying on the sizzle of having letters after anybody's name to do that, although we think that some of them are more important than the others, like the CFP designation or in fact, the law degree. Anyway, that's what I'm up to now. When we come back on the next segment, we're going to talk about what happens to an IRA when you die. We're going to talk about basically what the IRA is, and then we're going to give you some planning options in the third segment about how to make sure that you minimize the trouble and taxes that might be coming down the road. So stick with us. We'll be right back on Make It Last.
Hey, it's Bert. I hear a lot from people that the one asset they're most interested in protecting from the devastating cost of assisted living or nursing homes is their own home. The team at Medina Law Group can meet with you to discuss options to help protect that home, including their special Home Sweet Home Trust. It's designed specifically to protect the value of your home in the event that you need long-term care in the future. Just call the experienced elder law attorneys at Medina Law Group at 609-818-0068 to learn more, including your chance to schedule a free consultation. You can also visit MedinaLawGroup.com to learn more about protecting your assets and the Medina Law Group team. For peace of mind and a solid foundation, call Medina Law Group at 609-818-0068 or visit MedinaLawGroup.com.
Hey everybody, welcome back to Make It Last. We're talking today about IRAs and specifically what happens to an IRA after you die. So When I talk about IRAs, I talk generally about that term to cover all of the kind of pre-retirement defined contribution accounts that you have. I just got about half of you to roll your eyes in the back of your head because I use too many big words. But, instead of a pension, which we would call defined benefit, more and more companies are offering defined contributions. Now, defined contributions are you save your own money as opposed to the company putting it aside for you. And those have taken different forms: 401ks, SEP plans, 403bs, 457s. There are all kinds of numbers around them. And they all seem to start with 4 and they've got letters. But at the end of the day, that account essentially is money that you have set aside pre-tax. And you've set it aside and you got some tax savings for doing so, by the way. When you put it aside, you got to take that money off of your reported income, even though the company gave it to you because you contributed under the rules that they had to an account that would essentially hold it pre-tax. You got to deduct that for the most part off of your taxes. You didn't pay taxes on the money that came in. More importantly, that account has grown over the years that you have been saving and investing it. And now we're at a point in time where we need to make some withdrawals off of it. But just as we would expect, the IRS is going to look for their tax money. They're going to look for that income tax to be paid on any amount that comes out of there. Now, I have collectively called that an IRA for the most part because when we manage the money, we roll it over and we put it with an account at Charles Schwab. They're holding that. We invest it. We tell them what to do with it, but it's in a traditional IRA. Now, an IRA can take a couple of different forms. I've talked to you about a traditional IRA, but people are also familiar with a Roth IRA. Now, I intend to do a show completely on Roth IRAs, but for purposes of this show, let's just call a Roth IRA the tax-free account, because that's the one that you hold and you don't have to pay any income taxes on it. You have to pay income taxes on the growth, and you don't have to pay income taxes on the distributions that come out. Now, there's one special rule about the Roth IRA that's different from the traditional IRA, which is that you are never required to take any money out of that Roth IRA, no matter how old you get. With a traditional IRA, you've got to take that money out when you turn 70 and a half, and we call those RMDs, or required minimum distributions. That's basically the federal government saying to you, we're not going to let you keep this money tax-free forever. You're required to spend some of that down, and every year there's a certain percentage that you have to take out, and that's what we call our RMDs. Now, that traditional IRA will continue on. Some people will exhaust it. They will use all of the money in there. But research has shown more and more that most people will not use the money that's in there. Now, why is that the case? Well, most people subscribe to some research that was published that says that you can safely withdraw 4% on an annual basis. Now, that 4% ties nicely and neatly into the RMD schedule, because the RMD schedule starts at about 3.65%, goes up annually, but because the account value is going, sometimes going down for what you take out, the idea is that it's going to be a level set of distributions. But people will know that you can safely take 4%. Now, what the research has not been very clear about, and what most people don't understand, is that 4% number was based on some math that was a worst case scenario to ensure that people would not run out of money when they die. And what it did was kind of run a number of calculations over and over again, trying to get to the number percentage that said, look, even if you had the worst part of a 30-year run on the stock market, you wouldn't run out of money. But the way that math works out is that most people will not experience the worst 30 years during their retirement. So what ends up happening is that because performance is better than the worst 30 years, it turns out that there's actually more money left in the IRA than what they ever took out, because their account values over the long haul are growing. They're growing at better than 4%, especially if they're looking at it over a course of 25 or 30 years. And so, largely speaking, there's more money there left over. And so people need to plan for what will happen to that money when they're gone. Now, an IRA is kind of an interesting investment account because it's a contract with a custodian. Most people overlook that. They think it's their money. They think that, okay, but that's my account. It's actually not your account. You don't own the account. And that has to do with some federal rules, because if you owned the account, the federal rules would say you'd have to pay taxes on the money that's in there. So instead of you owning the account, the IRA is held by a custodian for your benefit. So the account is actually registered with the custodian. When we open an IRA, it's the checks that are made out to pay that into are made out to Charles Schwab for the benefit of, let's say, Victor Medina. Right, because it's my IRA account. You're holding it, you, the custodian's holding it for my benefit. And so because it's a contract, basically the custodian saying we're going to hold that money for you, it means that the disposition of that money, what happens to it after you die, is governed by the contractual rules that are associated with that account. Now, we call those beneficiary designations. And what that essentially means is that we have designated a beneficiary to receive the value of that account after we die, to be the beneficiary of the account that we have set up. Now, you're going to do that with a Roth, and you're going to do that with a traditional IRA. But the idea is that after you have passed away, the custodian will look at the beneficiary on file, and it will pay that money out to them. Now, it's going to give them some options, which I'm going to talk about in the third segment. But the idea here is to remember that IRAs and Roth IRAs do not go according to your will. Most people are under the impression that everything is going to go through their will. But the truth of the matter is that it's really not. What will happen is that we'll go according to your beneficiary. And when that beneficiary is listed, the company has to follow those contractual rules. It can't read anything else into that. It just has to follow what's listed. And most people will list a spouse if they're married, and then their children if they've got them. And, if not, they'll find somebody else to be listed as a beneficiary. But the absolute worst thing that can happen is to have no beneficiary listed, or in fact, to list essentially your estate. That's a mistake. We don't want to list your estate as the beneficiary of your IRA account. Now, it's important that we know what those beneficiaries are, because the way that we name those beneficiaries has a big impact on how we are going to be able to minimize the tax and trouble when we're gone. So now that you understand a little bit about the IRAs, how they're set up, kind of what the field of play is, when we come back on the next segment, what we're going to do is we're going to talk about how to structure your IRA so that after you die, you take advantage of the best kind of planning to kind of minimize the amount of taxes that will be owed and the trouble that will occur by making any mistakes along the way. So stick with us. When we come back on Make It Last, we're going to talk to you a few tips on how to structure your IRA for the time after you're gone. Now, I'll be gone, and we'll be right back.
Hey folks, there are more than 500 different ways to claim your Social Security benefits, and most Americans will rely on their IRAs and 401ks to survive retirement. The pressure to make the right decisions at this stage of life can be enormous, as are the consequences for making a wrong decision. Victor Medina, host of Make It Last, is a certified financial planner that specializes in helping people in or nearing retirement, working with families that have been diligent savers and who value a trusted advisor. Victor is able to put together a customized total protection retirement plan that helps clients answer 4 important questions. Can you afford to retire? Are you overpaying your income taxes? Can your portfolio be improved? Can you eliminate or reduce threats to your retirement? It's never been more important to make sure your ducks are in a row, and it's never been harder to make your nest egg secure. The time to act is now. Call 609-476-9269 or email info@privateclientfamily.com to schedule your no-cost, no-obligation first meeting and get on the road to total protection.
Everybody, welcome back to Make It Last. We've been talking about IRAs, what happens to them after you die. We talked in the last segment about, sort of the rules about IRAs, how they're set up, how they're held by custodians. And, I finished talking about beneficiary designations, and that leads very nicely into a discussion about how to set up these things to make sure that there is the right kind of planning. Now, remember that the traditional IRA essentially is an account that has never had taxes paid on it. And when you turn 70 and a half, the federal government required you to take money out and pay income taxes on that money as if you were earning that as wages. So that's what we call ordinary income. And that is that's a non-negotiable. When it comes out, if it was pre-tax contributions, when it comes out, it gets added to your taxable income. And if you're interested in learning more about how to proactively plan for your own income taxes, I'm going to urge you to go back to one of our prior episodes. Go on to iTunes on Make It Last, search for that, or go to the website, makeitlastradio.com, search for proactive income tax planning and listen to that episode. But along the way, money has to come out and you pay taxes on it. But when you die, if there is money that is left over in that IRA, it's going to pay out to the beneficiary. And here's why it's really important to make sure that the beneficiary you've designated is the right kind of beneficiary. Now, you basically have three different options there. You've got a charity, you have a natural person, or you have an entity. Okay. Now, a non-natural person entity might be your estate, or in many kinds of our planning, a trust, because we use trusts a lot in our planning. Now, our trust is a little bit different than kind of most trusts, because in our trust, we make sure that we've written it, that the IRS will look at the trust and actually call the trust an individual for tax purposes, and that's important. When you leave it to charity, all the income tax is tax-free. So you want to leave it all to a charity, that's fine. But not most of my clients don't want to do that, right? Most of my clients want to leave it to a particular person, typically children or spouse. When we name it to one of those individuals, we get some preferential tax treatment. So we've got one of the trusts that we write that looks like a person, or we actually name it as a person. We're going to get some preferential tax treatments, and the kind of tax treatment we get and the options that we have depend on who that person is to us. Now, if we have a spouse named, we'll have the option to do one of two things. The first is we can keep that account registered in the person who has died, in their name. And essentially, we can leave it there and continue to take distributions out of that account according to that person's life expectancy. Now, you might have gotten turned around in that, but the idea here is that if your spouse was younger than you, it might be worthwhile to leave that account as is, because the size of the distributions is going to be smaller. All right, smaller because they are younger than you. If, in fact, your spouse, you died and your spouse was younger, they're going to have the option to roll that into their own account. We're going to call that a spousal rollover. Now, the benefit of doing that is they get to treat the account as if they were their own. So now let's take our hypothetical family. We had a husband died at 75 taking distributions, and their spouse was 65 years old, younger than their required minimum distributions. By rolling that account over, we got to stop the RMDs and essentially wait another 5 years before we have to take another distribution, before it's forced out. So spousal rollover is pretty powerful, and only the spouse gets to roll that over and treat it that way. We don't get any more opportunity to do that. You don't have the opportunity to leave it to a child and allow them to roll it over. If you leave it to your children, what it becomes to them is an inherited IRA. That's a term of art, inherited IRA. The inherited IRA is essentially the ability for that child to then stretch out the taxes that would be owed on the distribution by only taking the life expectancy distributions that have to come out. So here's what I want you to think about. The children have their own RMD schedule. They don't get to delay it till they're 70 and a half. When they receive it as an inherited IRA, they must take a percentage out every year. And there's a whole schedule that is set to that, but they only have to take that percentage out. They don't have to take the entire amount. And what that allows them to do is continue to invest that account so that it grows faster than the distributions that come out. Distributions that might be owed on, let's say, a 40-year-old might only be about, 2% or so, 2.5%. Well, if I have an account that's growing at 5 or 7%, especially over the long haul, that 2% distribution means that there's going to be more money accumulating in the account than out of the account, right? So that is a way of stretching the IRA. Now, you can only stretch the IRA if you've named an individual. If you have named your estate as the IRA beneficiary, then what will happen is that you'll have to take all that money out no matter where it's going, no matter who it's going to, it can end up going to children. But you've got to take it out and then essentially pay the taxes over 5 years. It's as though you realize $500,000 as income in 1 year. Imagine the taxes that are owed on that. You're at the highest bracket on $500,000. So this is why it's really important to make sure that those beneficiary designations are correctly set up, because what we want, the result that we want, is we want the ability to stretch it out. We want to preserve that stretch out. And by the way, that stretch out is the same whether it's a Roth or a traditional. With a Roth IRA, when it becomes inherited, you still have to take those distributions. I remember when I said it's your Roth, you don't have to take any distributions out. But when you leave it as an inherited Roth IRA, you do have to take distributions out of there, and those distributions are tax-free. But what's nice is that if you're able to stretch that out, you've got tax-free growth for, 20 or 30 years. If you messed up the beneficiary designations, the money is not taxable, but then the growth on it is, because you have to take it all out within the 5-year period. So it's really important to make sure that we're able to stretch that out. Now, there's one more element I want to hit before we wrap up, which is that many of my clients, who are wonderful people, have children who are maybe not so wonderful. And what they're worried about is making sure that the children don't blow all of this money. Because if I leave it to them directly, right? If I leave them that money directly, they only have to take the required life expectancy distributions, their own RMDs. But they could take it all. I mean, it's found money to the kids, right? So what will happen? Well, I don't care what the taxes are. I want that money in my pocket. I'll pay the taxes and get what's left over. You're saying I get 60% left? That's 60% more than I had, if it's going to be at a 40% tax rate. So I'll take all of that right ahead of time. So that's why it's important to make sure that those accounts are properly titled to be owned by a trust. Because inside of a trust, what you're going to be able to do is keep it sometimes protected from them. So you might put somebody else in charge of the trust, right? Protect the child from themselves. Protect it from divorce and creditors. So now if I keep it inside of a trust and I don't allow it to all come out, I might be able to protect that from a divorce sometime in the future. And there's a recent case law that basically said an inherited IRA is not protected from creditors, but if I leave it in a trust, it is. So it becomes very important to have trust. So now, here is your marching orders before we wrap up for today. Review your beneficiary designations and check to make sure one of two things is the case. First, that it is properly titled. If you're married, put the spouse first. If you have children, make sure the children are listed as the contingent, and that you don't have anything in there that says, well, to my estate or according to my will, or just name the people that are in there. That's the baby steps. The PhD level planning, if you really care about this, get to the in front of an estate planning attorney who knows what they're doing and creating trusts for your benefit, so that when you leave that inherited IRA to the next generation, you're able to leave it protected. You got to be with a good estate planning attorney to do that, and your financial person needs to know how to title it the right way too. And so, there's some value if you can have that under one house, but definitely review those things to make sure that everything will work after you're gone, and that you will minimize the taxes and troubles that might come with an IRA after you're gone. All right, so we covered a lot today. Thanks so much for joining us. This has been Make It Last. Listen, if you like the show, please go on to iTunes and rate it highly for me, because that way other people that are searching for the best podcast and radio show on retirement matters will find Make It Last, and they will be as joyful as you are having listened to this program. If you have any questions for us, send them to feedback@makeitlastradio.com. Otherwise, we will catch you next Saturday on some other topic that will be equally as fascinating for you in your life as you near or enter retirement. This is Make It Last, helping you keep your legal ducks in a row and your financial nest egg secure. Catch you next Saturday.
The foregoing content reflects the opinions of Medina Law Group, LLC and Private Client Capital Group, LLC, and is subject to change at any time without notice. Content provided herein is for informational purposes only and should not be used or construed as investment or legal advice or a recommendation regarding the purchase or sale of any security or to follow any legal strategy. There is no guarantee that the strategies, statements, opinions, or forecasts provided herein will prove to be correct. Past performance is not a guarantee of future results. Indices are not available for direct investment. Any investor who attempts to mimic the performance of an index would incur fees and expenses which would reduce returns. All investing involves risk, including the potential for loss of principal. There's no guarantee that any investment plan or strategy will be successful. We recommend that you consult with a professional dedicated to your needs.